going to shift this
All right.
a little bit. There we go.
All right. Well, thank you all for joining us today. We are here with Colin of Angus and Terry, and it is November 2nd, and we are going to be talking about solar, EV charging stations, and I think some other exciting things today during our Collins Management University.
ADUs.
ADUs. Okay, I got 2 out of 3.
Yeah, it's passing grade.
Hey, 80%,
right.
man.
I'd like to acknowledge first Brad's awesome background, spooky Halloween-based background, which I was not able to find a background for myself. But yes, so this is recording in the usual lawyer word caveat warning kind of piece of advice is that I'll be giving you general statements about the law today. I will not be giving specific legal advice for your specific situation, right? Every case is different, and the lawyer needs to evaluate the facts and the law in order to render a legal opinion. So don't rely on my statements here in terms of, a specific situation. If you need legal advice, contact an attorney, and he or she will be happy to help you. All right, so that's the caveat, the warning, the Latin phrase. And with, let me see if I can share my screen. Window. Yeah, here we go. All right, you guys let me know this shares. Are you seeing anything?
Not yet.
No? Oh, wait, here it goes.
It's starting now. Here you go. Yep.
Okay. Now it says you presenting.
Who's that guy?
Yeah, it's not. That's a bottom of the sea guy. Just kidding. All right. Hopefully, I can advance the screen from here. You can't move this presentation, but I know how I can do it. I can pull up the PowerPoint myself. There. All right. Hang on. I'm working on it, guys. They didn't teach this at law school. Hey, did you hear that my dog can't read out? But my get it? Cat scan? Anyone?
I think you
Are you
were
there?
coming in
breaking
and
up.
out. We couldn't hear that.
We couldn't hear the joke.
Too
We
much
missed it.
video. Okay, did you hear that my dog can't read MRIs?
No.
My cats can. Right.
That's a
Good
good
one.
one.
That was definitely funnier the second time.
All right. Thank you. I worry about my internet connection. I was going to do this from an office, but kids' schedules prevented it. I'm trying to, that's not working. All right. Let me see. Okay. So
if
that's
you
me.
did at the very bottom. Oh, wait. It is progressing now.
Okay. That's me. This is our firm. We've been doing this for 35 years. We're doing it in 3 states now. We've done it forever in California. One of the first firms to do association law. We do both general counsel, which is what we're going to be talking about today, and construction defect work. So if you have an association that has some issues and it's under 10 years old within the limitations period, let us know and we can help assist you with getting repairs done. We believe we have superior, responsive, reasonably priced legal counsel. Any new associations who sign up with us get a reduced hourly rate, $3.50 an hour, regardless of who's working on it, whether it's an associate or the partner, the managing partner, Julie. It's all at the same rate, $3.50 for the first 6 months. And you get a board training, which we find is sometimes helpful when you have a board that doesn't get along or is doing things they shouldn't be doing, and you're having difficulty managing them, a good talk from legal about their responsibilities and their risks will frequently help you better manage your association. And that's free if we sign up a new association as part of that deal. You can text Julie about that. We're sending her an email and she'll be happy to help. So, okay. I gave you the disclaimer already. It's not legal advice, but a summary of the law. So let us know if you have specific issues and we'll be happy to help. All right, solar energy systems. These are encoded in our statutes and civil code sections 714, 4600, and 4746. The latter of those two are part of the Data of the Sterling Act, and they apply to your associations. Associations must allow the installation of solar energy systems on the roof of the building in which an owner resides, on a garage or carport adjacent to the building that has been assigned to an owner. Now that includes when you go to, well, first let's talk about solar energy systems. It's a broad-based term for any kind of solar equipment that provides energy. Solar panels and their components is basically what that means. So the state law requires that broadly, and that associations must allow the installation. There are specific requirements when it comes to common area roofs, and that's what the Davis-Sterling Act addresses in conjunction with that other statute that I just read. And basically, 4600 says that, generally speaking, that if you were to give common area for exclusive use to somebody for a purpose other than solar energy systems, the law requires you to obtain approval of 67% of the owners to do that, right? So generally speaking, if you were to say, grant some common area yard space to an adjoining lot owner so that they could expand their lot and have more common area, you couldn't do that without a vote. And so, two, you ordinarily would not be able to give a share of the common area roof that you maintain to somebody to put their own solar system on it. And so this 4600 says that provision of the law doesn't apply. So if an owner comes to you and wants to put a solar system on the top of a common area roof in a building in which his unit or townhome is, you have to do it and you don't have to put it out to a member vote. But there are some requirements, and that's where 4746 comes back. And it says that you can, as the association, require the owner to do a bunch of things. The first thing you would have to do, which makes total sense if it's on a common area roof, is notice every other owner that's in that that has that common roof shared, in case they want to do something on it. And they're given notice because they're going to be affected. And I'm not sure if it's on the slides or not, but maybe it is. But as part of that notification and installation, and in your architectural app, you'll require these owners to do a roof survey to know how much of that roof is going to be occupied by this person's exclusive use solar energy system. So the other thing that you're going to require, because if they're one owner is putting something on common area property, is insurance. So they're going to have to be responsible for any damage that thing causes. And so the law allows you to require them to have insurance and provide proof of that on an annual basis. So what that means is, for your association, is that you should create some rules around this that comply with the law. so that you can get what you need out of these owners without having to do a laborious, architectural application. You have the rules in place, they're equally applicable to everyone, and you don't run the risk of treating different people differently. And you make it a requirement, all of these things that are allowed by the statute, that the system be prepared and installed by a licensed contractor, and that this roof survey that I was talking about is done, so that it's equitable, or that people know what percentage of the roof is going to be available for their system later. And then you obviously want to have who pays for the damage, the person who's installing it, right? So if they install it and they bust a hole in the roof and it leaks, then you want to be able to go after the person who installed it. Same thing for the maintenance and repair of the system. You want to make sure that because it's their system, they understand that even though it's on the roof, they have to maintain and repair and replace it. And that they also have to disclose to people who are going to buy their unit in the future that, hey, you're responsible for all of this. And the way you do that is by a covenant. So you make a requirement as part of the architectural application that they sign a covenant that has all these things in it. And then you record it with the county recorder, and then it runs with the land, and everybody's obligated to it. The great thing about the statute from the association's perspective is that you may charge the owner for the preparation of that covenant. So all of these things assume that the owner is going to pay for any costs that are associated with the installation of the system on common area property. So there isn't any obligation that the association pay for any of this stuff. It's just a statement that says that you, as the association, you can't prevent this. And then it gives you a framework to, because you can't prevent it, to control it and regulate it. And so it's pretty important if your association doesn't have one of these policies in place, you'd want to get one in place, because it will make all of these statutory requirements explicit, and there won't be any questions, and then it can be self-executing. And then you can get that covenant recorded, because it'll be part of the requirement of your rules that anybody who presents one of these things has to do a covenant. Okay, so that's probably the next one. I probably jumped ahead of myself. Okay, well, these are potential rules that you could put in place where you want to limit the placement and visibility. Potentially, you could do that in your rules as long as you allow it. Require notice to the homeowners. Again, that's kind of required by statute, depending on the roof type, if it's a shared roof. Require the homeowner's liability insurance, the solar survey, require architectural applications, and require them to maintain it and repair it, and require disclosure to the prospective buyers, and then have all of that wrapped up into a covenant, which includes, a good point, indemnification, right? So that if somebody sues the association for damage or injuries caused by the solar system, the owner has to indemnify you, the association. So those are kind of the broad strokes of this agreement. Or the kind of the rules that you should try and have in place at your association, because your takeaway from this is that solar energy systems are allowed. The associations can't prohibit them. And so you should put rules in place to govern them. All right. Now, I think we're going to transition to the next topic. And as we do, I was wondering if anybody knows where they make average kind of things. Does anyone know? At the satisfactory. No. At the satisfactory. All right. That one's pretty bad. Thank you, Melanie. Appreciate it. All right. Everyone's favorite subject and a personal favorite of mine, accessory dwelling units. It's the same thing. So the theme for all three of these things that we're talking about today, electric vehicle charging stations, solar panels, and ADUs, your associations no longer can prohibit them. You know, before 2018, 2019, you could stop all these things from happening. But the legislation is being enacted to prevent you from doing that. And the arguable basis for the solar panels and EV electric vehicle charging stations is for climate change and preventing that and helping that, so that they want to facilitate it. And then for ADUs, it's the housing crisis, and this is their proposed, or one of their proposed relief mechanisms for it. So again, the takeaway here, you cannot prevent it. So if you can't prevent it, you should have a policy in place that regulates it. That's the that's the general gist of it. All right, this is talked about why it's in place. It's in place because of the lack of affordable housing, more homeless people, and people with stable or inconsistent housing, moving from rent to rent, different places. So, and what this did, this was the older legislation. It allowed conversion of existing developments and allowed started to get rid of some restrictions, right? And then it explicitly prohibited governing documents from being enforced if they restricted or prohibited their construction or use. So you can't bar their construction, and any provisions that unreasonably restrict their building or use are unenforceable. So these are all similar statutes that are designed. This is a little advanced, it's a little technical stuff, but the general thrust of all these statutes over the last 5 years has been to make it so that accessory dwelling units may be put anywhere and everywhere. All right, and so it may be helpful for you to understand what is an accessory dwelling unit. It's this, what you see on your screen. It's a second unit on a lot up to 1,200 square feet. It can be either completely detached or attached to the primary residence, and it must have cooking, sleeping, and bathroom facilities to qualify as an accessory dwelling unit. Now, there's another one, a junior accessory dwelling unit, and the main difference from that is that it doesn't require those bathrooms be independent in it. It can share the bathroom with the main residence as well as the cooking and sleeping facilities. So it's smaller, and it can be placed in places like garages or patio storage closets and things like that. It's a really kind of flexible, if you read the statute, rule that requires you to allow it. And that's the way the statute is written. It's required to allow these things. So this is more of the same. They can be added on. Attached conversions can't exceed 50% of the primary dwelling. JADUs can't exceed 500 square feet and must be entirely within the primary residence. But if that's a garage or a storage space, that's included. So the impact of these on the enforceability of your CC&Rs is in several places, right? So the law has changed setback requirements, for example. So if your association has setback requirements for additional structures, they aren't enforceable anymore as to ADUs. So the ADU can be as close as 4 feet to the property line, to an adjoining lot line. And it can be 17 feet tall And now I think the new law says they can be 25 feet tall. And that's to accommodate 2 stories. So the real trend here is to kind of urbanize everything and make everything packed in, so that more and more residents can have space to live. It does impact your occupancy provisions in your CCNRs, right? Because now you've got an extra living space in there. And so if your CCNRs are say only 5 people per residence, that's kind of not going to apply. So the 2+1 rule probably would apply, and it would add two more people to the mix. Parking, it's going to throw a wrench in your parking policies because the state requires that these ADUs be allowed without the requirement of an additional parking spot. So you can't make it a condition of the construction of the ADU that they find parking somewhere. It has to fit within the existing parking framework. On your rentals, and in particular with your rental percentage caps, these do not apply if you have an association that has a rental cap. Say 25% of your association can be rented out at any given time. We'll add on to that 25% any ADUs, because the ADUs are exempt from that rental cap provision. It will have an impact potential on assessments and budgeting for common area expenses. If there's an impact on common area expenses from the additional facilities, you can correlate fees if you can provide an evidence-based reason to charge more fees to this particular ADUs. That's all right, but it can't be unreasonably restrictive. So it can't be designed to make it difficult for them to live in it, because that would contravene the statute. You got to be careful about maintenance allocations, especially if you're in like a townhome situation, or there's a JADU in a condo for somebody decides to build one in a garage for a condo. You'll want to have, similar to the solar systems, you want to have a policy in place that makes them do certain things vis-a-vis those ADUs, i.e., who's going to be in charge of the maintenance for it. And you'll want to put it all on the person who's installing the ADU. Okay. So this is more like in the weeds kind of stuff about reasonable restrictions. You can't be arbitrary. That's what I was just talking about. It has to have you can't say, well, you've got an ADU, so we're now going to charge you $500 extra a month. And there's no basis for that. And that would be an arbitrary restriction. But if there's increased garbage and your garbage costs go up or something like that, you could tag the increased costs in your garbage as a result of the ADU to the owner of the ADU. One thing that you'll want to think about is lot splitting. For those of you who manage associations and plan developments with lots and residents on the lots, you want to change your CCNRs to prevent lot splitting, because there's a law in the books that allows associations to or owners of property to split their lots and build another residence on it. This is kind of tangentially related to ADUs because in the next legislative session, there's going to be a new law that says that you can now sell your ADU separate from your residence. So if your association has a restriction on lot splitting, that restriction is still enforceable per some of the guidance that relates to that legislation. So if you manage those developments, you should check your CCNRs and make sure that they have a no lot splitting provision. And if they don't, update them so that people aren't splitting their lots and you're adding numbers of units to your thing, your development, and stirring up all sorts of things with everything from budgeting to assessments, and in between. So, okay. So that is the ADUs. Now we're going to transition to electric vehicle charging stations. Did you guys hear that I can't spell the word Armageddon? It's not the end of the world. All right. Electric vehicle charging stations. This is pretty much the same thing as the solar panels, which is that your association may not restrict the installation of or prohibit the installation of an electric vehicle charging station in a deeded or exclusive use parking spot. Moreover, if there is an individual who wants to install one and it's not possible for them to do it in a deeded or exclusive use common area parking spot, then the association is required to make common area available to them so that they can install it. Reasons for the impossibility might be something like space or impossibility or really expensive electricity upgrades in a spot that makes it difficult, in which case the law would require that common area be made available to this person to install their EVCS if they wanted to, and it wasn't unreasonably expensive to do so. So what you're seeing up here is the recent legislation that talks about the making mandatory and uniform the installation of the charging systems. Because right now, what you will see is part of the applications, they will have different levels of outlets basically for the vehicles. There will be anything from a standard outlet, which takes like 16 hours for it to charge, to I think it's called a level 2 or something like that, which is a 4 to 6 hour charge. And those are like electrician type things, but the government wants to mandate them so that the installation is uniform and more efficient. So, but it's the same thing in terms of wanting to have a policy in place, because again, a lot of times, if it's deeded or if it's an exclusive use spot, there will be impacts to the common area. There may be installation through common area walls or hooking up to common area electricity, and things like that. So there should be a policy in place that has a lot of those same things that we talked about for the solar system. Who's going to construct it? How's it going to be constructed? Who gets to use it? And who has to repair it, maintain it? Who is required to insure it? And most of that is going to be, again, requiring the owner to do all of that. And then, again, you're going to want to have another one of those agreements in place that has them, hold the association harmless from any lawsuits that result from the charging station. We do strongly recommend that you have a policy in place to help guide you with these things and not just rely on your regular architectural application, because it is something that it has to be allowed for the most part. And if it has to be allowed, then you should have procedures in place that guide it. Those are kind of the broad strokes of those 3 different type policies, and what you should be on the lookout for in terms of that for your association. I'm happy to take any questions if you want. Let me see if I can And done there. So, okay. I'm back, I think. All right. So
Nobody has any questions? That must mean that you did an amazing job, Colin.
that's right. Oh, Nicole's got a question. Fire away, Nicole.
I do have a question. So I have an association that has deeded carport spaces. So if hypothetically they wanted to put in if a homeowner wanted to put in an EV charging station, the board would kind of have to give a special accommodation for them to create some area for the EV charging station and common area parking.
Well, no, they should put it in their deeded spot.
Okay.
They should put it in their deeded spot, but it should be pursuant to an architectural application at least, most likely. And again, if you don't have a policy in place for that association, you should get one, because once one person installs it, somebody else is going to say, oh, you know what, I want one too. And then you're going to want to have all of those statutory requirements in place.
Okay. So let me ask another question then. So we go through the architectural process and everything like that, and and they cut into common area to run electrical lines. They have to restore my common area, correct?
Yes, they do.
Okay.
And that's why you want to, that's why the covenant is important. You want to have a covenant that makes them do that. And not only that, but later when it damages it, or when there's a leak through that, through the wall because of the EVCS, right? You're going to want to make them pay for that.
Thank you. You'll probably be hearing from me soon.
All right. No problem. Tanisha, did you also have a question? Maybe that.
And they have someone that has an ADU unit. Can you hear me?
Yes, I can now. Yeah.
One of the visitor parking spaces may be like, I'm saying like, so if they don't have any parking spaces for the new people that live in the ADU unit, they just
So the law is that an ADU has to be allowed without additional parking requirements if the development is within a half a mile of public transportation. So it could be the case that your development is out in the boonies somewhere where there's no public transportation. But most likely it's going to be within a half mile of public transportation, in which case you cannot require additional parking spots as a result or as a condition of allowing the ADU to be installed. And so what we generally recommend doing is just sharpening up your parking policy to one that has everybody who's an owner or resident with a sticker and things like that, depending on your circumstances, so that you know whose vehicles are yours and whose are not supposed to be there in terms of the public. And then you can reduce the parking traffic on your private property that way if people from the public are parking on it. Did that answer your question, Tanisha? All right, I'm going to take your silence as an admission, as I'm allowed to do by Cal Evidence Code 1152.
Tanisha, I don't know why we can't hear you.
okay.
You sound far away. That's better.
Wait, there you go.
Oh, okay. I said yes. That answered my question. Thank you.
Oh, you're quite welcome. Diana.
I have a question about the charging stations. We have a community where they just asked everybody not to plug things into their garage because the association pays for all the power in the garage. And so they do want to start putting in charging stations, but a big question is how are they going to charge for that if some people have charging stations and other people don't have, an EV vehicle, how they could come up with something fair because the association will be paying the electrical expense.
There are metering companies that are associated with these EVCSs, and I can't think of any of the names off the top of my head, but whoever is going to install that EVCS will know the companies that you can contact to put in something like charge your credit card or, identify it with a particular vehicle or means like that. So there are systems in place. And then the caveat or warning there is to make sure that you're reviewing the contract with this vendor so that it's, favorable terms to the association and that you're not agreeing to things on behalf of the association that you wouldn't want to. But there are standardized services out there that will do that will allocate it for you. Yeah.
Excellent. Thank you.
Mm-hmm. Anybody
Hey,
else?
Colin, it's Brad.
Yeah.
Hey, I just want to recap really quick. You are suggesting that HOAs have a policy for solar, for EV charging stations, and another policy for ADU installation of ADU units, if applicable.
Yes.
Gotcha. Okay, so just making sure that for the listeners on the line here, they understand that this is something that we should be working towards getting our HOAs compliant and making sure that they have these policies on file.
Yeah. It will make everything a lot smoother if you have it, and it will save you time, and it'll save you money in the long run. Your boards will object to the very reasonable price tags that are offered. But it's a case of being penny wise and pound foolish, because if you don't have it in place and then 2 years down the road, there's a huge water loss claim because of one of these charging stations or something like that. And then you're paying a lot of money out of pocket when you could have been holding that owner accountable for it. So that's the way we generally, recommend it. Nobody likes us lawyers charging money, but we do think we save people money in the long run.
I have a question.
Sure.
So we're starting to see more associations interested in putting EV charging stations for the community. So instead of having an individual person have their charger in their carport or their deeded spot, to have a common area location. So my question is, let's say we have an association where the parking spaces are considered common area. Does the board have the authority to convert those common area parking spaces to EV charging station parking spaces?
It would depend on the language of your CCNRs, but in theory, if they are common area and owned by everyone together, and the usage of the charging station is going to be in theory for everyone and not just exclusively to one person, then yeah, they would have the general authority to do that. So two things jump out at me is that one thing is that I had a client ask me that if they do that, can they prevent people from putting them in their deeded spots or their exclusive use spots? And the answer to that is no. It's like a tactic to put it off, saying, oh, you don't need one, we've got one here. But if there was a persistent owner, he or she would have to be allowed to nonetheless put it in their deeded spot unless it was like really impossible. And then again, if it's really impossible, the statute says that you have to try and give them some common area to do it, which is crazy. And I've not seen that happen yet.
Mm-hmm.
Yes, I'm not seeing it, but that's what the statute says.
Okay, let's say their spots aren't deeded, they're assigned. Would that still have the same clout in terms of a particular owner being able to install in their assigned spot?
Oh, they should be permitted to install in their deeded spot. Are you saying there's a deeded and an assigned spot?
I'm saying that they have no deeded spot.
Oh, okay. Yeah, and everything is common area?
Well, the documents allow for common area and then assigned parking.
Yeah, assigned is basically exclusive use. So, right, so if they're getting assigned parking, they alone get to use that spot, then that's essentially an exclusive use spot. And then I think the application of the law would be that they probably have to be allowed to install it where in their assigned spot. But that's
Okay.
where it becomes important to have a covenant in place, because you'll want to make sure that when that guy leaves, he has to take that charging station down, unless his successor is gonna want it, right? So one of the things we do in our policy is we make sure that when the person sells or transfers their property, that if the removal is required, and it might be in that situation because it was just assigned, that they remove that at their own expense.
Okay, thank you.
You're welcome. Nancy.
Oh, I just want to make sure I understand. I hope I'm misunderstanding something. So what you said a minute ago, and something you talked about during the next to the last slide that you showed. Let me say it this way. A former property that I had, very spread out. People had assigned parking, deeded parking spaces, but there were also a fair number of not deeded general parking for people. The few owners that wanted to put in electric charging stations found that it was prohibitively expensive for them because they had to run power from their deeded space to the electricity that served their building. You're not saying that because it's too expensive for them to do it because of their location, they need to have access to a common area parking space?
I might be saying that. I would have to look at it. The one thing jumps out at me, though, is because I did have this earlier. It depends on what you mean by prohibitively expensive, right? Is like that. What does that mean? Because these things cost about $5 to $8 grand to get installed. So
Right.
if I were to install one right here in my garage, it's not cheap, right? So that's the first hurdle. If it's not, twice the value of the car or something like that, then there's an argument to be made that it's not prohibitively expensive. And just because you think it's expensive doesn't mean that it is. And so the law says that unreasonably expensive. So you're not doing anything to make it unreasonably expensive. So that's the first instance. And then in the second instance, if it were to be construed as prohibitively expensive, then depending on what your CC&Rs say vis-a-vis the common area parking spaces, the statute likely would require you to make a common area spot available to them.
Fortunately, this is a hypothetical case at this point, but because you mentioned it twice, I wanted to ask. So thank you.
Yeah.
That makes sense. Yeah.
When
So
it becomes not hypothetical, feel free to reach out.
I absolutely will. Thank you.
You're welcome. All right. What do you call a cow on the floor? Brad? Yeah. There you go. I've said that one enough now.
What was it? I missed it.
Go on, Brad.
What do you call a cow with no legs? Ground beef.
Yes.
Oh,
I have a disciple.
There's a second part to that one too. That's not work appropriate.
Well, I don't know that one. You're gonna have to email that to me.
No.
Oh, all right, guys. Anything else? Can I answer any other questions? Go ahead, Nancy, if you really want to.
She's got a hard one, I'm sure. She's
You're
shaking
muted.
her head.
You're muted.
I know I always have a hard one. And again, this is not, but I read that law just the other day that's pending about if that ADUs can be sold,
Yes.
but it said something very strange about, but it does not, they don't become a member of the association, which made no sense to me. Are they saying the seller or the person who buys the ADU? And again, this is hypothetical. I just kept reading it, trying to make sense of it. So
I haven't read the new law yet, full caveat, but I've only heard people discuss it and read some kind of summaries of it. But my understanding is that it can be sold like a condominium, is how it was phrased.
right.
You know, like if it's part of your house, it then becomes a separate, it can be deeded, I guess, but I don't know the answer to that. I've got to look at it because I think that I was confused by that as well. Like what does that mean for associations? And that's why I want you all to prevent lot splitting on your,
Yeah.
your associations. Because it is going to throw everything into kind of chaos unless there's they've accounted for it in the statute. And so, in my defense is that we haven't done our updated law stuff yet. So that's when I'll read that and I'll get you up to speed on it.
I just happened to see that and
Yeah.
it made no sense. So
Well, I predicted this because they did, when I did the ADU presentation about a year ago, they said that they were not, that it was explicit in the statute that says you're not allowed to sell them as a separate
right.
entity, but there was a carve out for low income properties. So low income properties were allowed to sell them off. And I said, what this means is in a couple of years, they're going to change it and they're going to allow the main ones to be sold. And it looks like it's started on that, if not already there.
Yeah.
Yeah. It's crazy.
Yep.
So,
thanks.
you're welcome. All right. Thanks, everyone. We'll see you
Thank you
next
for your
time.
time today, Colin.
Oh, you're quite welcome.
Bye.
Bye-bye. Let me know if
Colin.
you guys have any questions. Feel free to email me. Melanie and Brad have my email if you need it. All right.
And can you send me the PowerPoint when you get a chance to?
I can. Yeah, I'll send you right now.
Okay, awesome. Thank you so much.
You're welcome.
Okay, bye guys.
I don't know what I just did.